Good afternoon and welcome to the second argument on the afternoon docket for the Tuesday session of the March 2022 Court of Appeals oral arguments. My name is Leslie Ann Isherwood and I will be presiding over the hearings today. I would like to take a couple minutes to introduce the judges that are appearing with me, which is Judge Henry Green, who's been with our court since 1993, and Judge David Bruns, who's been with our court since 2011. Prior to the parties' arguments today, we have educated ourselves by reviewing your briefs and the corresponding records for this case, as well as a memorandum that's been prepared for us. But while we are intimately familiar with the facts of the case, that's not necessarily true for those who may be watching this argument live or the later archived version. So I have requested appellant's counsel to please provide a brief factual overview of the case so those that are watching can understand how it is we got to where we are. The case before the court is scheduled for 15-minute arguments per side. I will be keeping track of that time as well as the rebuttal time, so the parties are not required to do that. And with that, I would like to call our last case, which is number 123992 from Johnson County, John McCue versus David Bruce. And if the parties would please announce their appearances.
May it please the court, appellant John McCue appears by and through counsel Caroline Gurney.
May it please the court, appellee David Bruce appears through Rob Wasserman.
And Ms. Gurney, would you like to reserve any rebuttal time?
Yes, Judge, I'd like to reserve 5 minutes for rebuttal, please.
5 minutes is granted, and with that, you may begin.
May it please the court, good afternoon, your honors. I represent the appellant, John McCue, and we are asking this court to reverse the district court's judgment and order granting defendant's motion to enforce a settlement entered on February 21st of 2021. The issues in front of the court today that are intertwined are, number one, whether plaintiff's offer to settle for defendant's policy limits lapsed when defendant waited over 90 days to respond, and two, whether the district court erred when it ruled that the parties have an enforceable settlement for the policy limits of defendant's auto liability policy. To make this as simple as possible, this case comes down to whether it is reasonable for the insurance company to sit on a settlement offer for 3 months. And it's our position that that is not reasonable. For context, regarding the underlying case, this is an auto case. In November of 2014, plaintiff and defendant were in a car crash after defendant failed to yield the right-of-way and pulled out directly in front of plaintiff. Plaintiff, Mr. McCue, was badly injured. He was hospitalized and forced to undergo several surgeries, including hardware placement, placement of a wound vac, skin grafts, in order to repair his right ankle and his lower leg. On May 21st of 2020, plaintiff timely filed suit against defendant. I believe that the suit had been filed previously within the statute of limitations, dismissed, and then refiled, so it was on file timely. And then on June 30th, 2020, plaintiff's counsel sent a letter to defendant's counsel offering to settle the case for the defendant driver's auto policy limits. The offer to settle did not contain a time limit for response. Along with the letter, plaintiff's counsel sent a CD containing the police report evidencing a clear liability wreck and approximately 8,700 pages of medical records and billing records from plaintiff's treatment from his injuries from this accident. Over 90 days pass. Plaintiff doesn't hear anything from the insurance company. On September 29th, 2020, so we're 3 months later at this point, defense counsel contacts plaintiff's counsel with an offer of policy limits to settle the case and asks whether that offer of policy limits would be accepted. However, at this point, so much time has passed, the plaintiff's settlement offer has lapsed, such that there's nothing for the defendant to accept.
What's your basis for that? What's your authority to say it lapsed? I mean, isn't lapsing if you don't put a specific, it would have if they would have said, and I know your firm was not involved at that point, but if they would have said you have 30 days or you have 60 days, you have 90 days, whatever they had said. But since they did not specify a time, wouldn't it just be reasonableness? A reasonable amount of time?
Correct, Judge. The law is that if there's no time limit contained in the offer, the time to respond would be a reasonable time.
So it didn't necessarily lapse. You're just saying it was they responded in an unreasonable amount of time.
Well, I believe after a reasonable amount of time passes, then the offer has lapsed.
But you realize that reasonable means that you and I may both be reasonable people, and yet one might do an issue just a little different than the other and both be within the realm of reason. Correct?
Right.
I mean, there's no hard and set rule here is what I'm getting at.
Right. Well, the question is what's reasonable. And in this case, the insurance company sitting on the offer for over 90 days, that's not reasonable, such that.
Well, let's talk about that a little bit. Are you familiar with the Kansas Tort Claims Act?
A little bit. Okay.
And I don't want to put you on, I don't want to be like Senator John Kennedy, who puts, past people about motions in limine when there are projections. But let me just, if I understand it correctly, if you sue a municipality, so you sue a city, you sue the county, or you sue the state, you have to give them an opportunity to settle. And I believe statutorily, if I'm not, and I could be mistaken, but I believe that's 90 days. Do you know, or I can look it up?
That sounds correct. I don't have any reason to think that that's wrong.
And I would assume the 90 days was set to give a reasonable amount of time for them to examine the claim. In this case, to review 8,700 pages of medical records and billings, perhaps to have those reviewed by a consultant or expert to let them know, were these damages that are claimed caused by this accident, and then to respond. So how can we just say willy-nilly that this is unreasonable amount of time?
Well, it's unreasonable because here it's over 90 days from the date of the letter. And I mean, the insurance company, State Farm, defendants, insurer, they employ thousands and thousands of adjusters who are in the business of adjusting these claims. And this isn't a situation where we didn't provide all of the information and we're trying to hide the ball. This is a situation where we're saying, here's a police report showing that defendant pulled out in front of plaintiff.
Well, liability sounds fairly clear from what you're saying, but the stickler here, and it seems like the judge was just, I can't remember who the judge was. Who was the judge?
I believe Judge Vano.
Judge Vano, he seemed to really hang his hat on the fact that they had 8,700 pages to review. That's a little different than, I go to the emergency room and maybe have a little bit of follow-up treatment. But here there were a substantial amount of medical records that needed to not only be reviewed, but potentially have some outsider review to see whether or not there's a causal connection between that liability and the damages caused.
Well, I think there were 8,700 pages of medical records and billing records showing that it's pretty clear there was an accident and this guy was rushed to the hospital and he required several surgeries. And as far as the insurers having all of their adjusters, and they employ medical experts who can take a look at this, in several hours, get it looked at and get back to us. I mean, how do we know that?
Well, what's in the record to support that? I mean, you're probably right, but don't we have to rely on what's in the record?
Well, we have to rely on what's in the record, but we all know that the insurance company expects that their attorneys and everybody are going to move quickly. So they have adjusters and experts. We all know that. I mean, that's common knowledge. They have people who are moving quickly, and they are required to get the information, and we've provided all of the information. This isn't a situation, like I said, where we're trying to hide the ball. We're saying, here's clear liability. Here's showing there are hundreds of thousands of dollars in medical bills in a short amount of time related to this wreck. And we are making this demand or this offer to settle the case for policy limits.
Wouldn't it be just as reasonable once that happens, once, let's say, 60 days expired with no response, to send a letter and say, hey, the offer's off the table?
Well, I think in that situation, if it had been after 30 days or after 60 days and plaintiff's counsel writes a letter and says, hey, the offer's off the table, then there's no question. But I think here we're getting into 3 months, that's 90 days, where we didn't hear anything and plaintiff assumes, well, I haven't heard anything, I need to move forward and litigate this case. I mean, 3 months, that's not 30 days. That's just months where we are sitting here without any response from the insurance company. And I guess I'd like to go ahead and say, I mean, we mentioned in our brief KSA 40-2404, which offers some guidance because the insurance companies are supposed to be prompt in dealing with settlement negotiations. And defendant's going to say, well, the insurance company isn't a party here, but we all know that the insurance company is the one calling the shots as far as settlement authority, and they're evaluating the claim. They're the ones making the settlement decisions for their insured, and they're bound by those regulations. So again, the question is, well, what's reasonable here? Well, if KSA 40-2404 says that the insurance company is engaging in unfair claim settlement practices, if they're not attempting prompt, fair, and equitable settlements of a claim in which liability becomes reasonably clear, well, so if liability is clear, they need to be moving promptly to settle the claim for a fair amount. And that didn't happen here. I mean, there was nothing prompt about the way that the insurance company responded to this offer to settle.
Was your client prejudiced here? And if so, what was the prejudice?
Our client was prejudiced in the sense that he made a demand on the insurance company, and he's sitting here with no information, I mean, about what's going on.
But what I'm trying to get at is, did this prevent him from filing a lawsuit? Hadn't he already filed a lawsuit at this point?
The lawsuit had been filed prior to his making the claim. And so, or I'm sorry, prior to his sending this offer to settle. So yeah.
Because often the prejudice is, they played four corners and we didn't get to file our lawsuit in time. We couldn't make an uninsured or underinsured motorist claim, things like that. So I'm trying to figure out, other than, hey, this sounds unreasonable, was there any prejudice to your client? Is there anything he couldn't do because of this?
Well, I would say, apart from the emotional aggravation of not hearing from the insurance company, which he should have after he makes this offer to settle, he has to then have the stress of knowing I have to continue with this lawsuit. He has to get additional counsel involved. I believe his prior counsel wasn't going to litigate the case or take it to trial on his behalf. So he has to get other counsel involved, and we have to start preparing him to go forward in this litigation. So yes, he has the case on file. He was able to do that, but because the insurance company didn't respond in a prompt manner as they are supposed to, well, now he has to get my firm involved and get prepared to move forward with the trial.
Did the insurance company even acknowledge receipt of this? Was there any communications, or do you know? I mean, it's not in, I can't see it in the record. Did they respond and say, hey, we've got this, we're going to look at it, or was it just complete silence for 90 days?
As far as I'm aware, Judge, there was complete silence for 90 days. So that 90 days goes by, and then defense counsel sends correspondence to plaintiff's counsel and says that he is essentially extending this new offer. He says, I am extending the policy limits of $250,000 for the injury claim of your client for settlement of this claim. Please let me know if this is accepted. Okay, well, if this is a situation then where this is just an acceptance of plaintiff's settlement offer, which is essentially defendant's position here, then why does he have to ask whether it's accepted? You don't ask if an acceptance is accepted. You ask if an offer is accepted. But defendant knew, I think, that enough time had passed such that that June 30th offer was off the table. I mean, an unreasonable amount of time had passed, and the law is clear that if there's no response within that reasonable amount of time, then the offer has lapsed, it's off the table. So defendant's correspondence in that sense was not a true unconditional positive acceptance because there was nothing left open to accept. So defendant's request for confirmation of the acceptance just indicates that they knew that the passage of time had essentially nullified plaintiff's original settlement offer. And yes,
Ms. Gurney, your time has expired and you're moving into your rebuttal time, which you are certainly welcome to do, but we would have to dock that time from your rebuttal time.
I'll go ahead and pause here, but I would just ask the court to reverse the district court's judgment in order granting defendant's motion to enforce the settlement and remand the case for further proceedings.
Mr. Wasserman, you have 15 minutes.
Thank you, Your Honor. May it please the court. As appellant's counsel said, this case arises out of an accident that happened back in November 2017. The lawsuit was originally filed in November 2019. It was then dismissed without prejudice. It was dismissed without any discovery being exchanged between the parties. It was then refiled back in May of 2020. Mr. Bruce answered the petition in late June 2020. And a few days later, Mr. McCue's attorney mailed a demand letter to the office of Mr. Bruce's counsel. The demand letter didn't describe his injuries other than I think saying that they were serious. Enclosed with the demand letter was, as has already been discussed, a CD containing a police report, medical records, medical bills that totaled over 8,700 pages. And I think it's important to note that this was the first demand that had been received in this case. This was also the first time that Mr. Bruce's counsel or his insurer had received any treatment records. This is really the first indication that they have, what the nature and extent of his injuries were.
Mr. Wasserman, if I could interrupt you for just a moment. So there's been some speculation as to what was or was not occurring during that 90-day period. Can you offer any insight into what the status of that case was at the time that 90 days expired?
Sure, Your Honor. So I was not involved with the case back when the demand was submitted, or when the demand was mailed in June 2020. That was Mr. Williams. As far as I know, the demand likely would have been submitted to the insurance company. The insurer and Mr. Bruce's attorneys would have undertaken a thorough review of his records and analyzed the treatments he received, the bills he incurred, and evaluated the case and determined whether the policy limits demand should be accepted. As far as what was happening in the litigation, my understanding is there wasn't much happening. I know that the suit had just recently been filed, but that's.
What about my question earlier for Ms. Gurney? Did anybody respond to defense counsel, to the insurance company? Anybody say, hey, at least acknowledge your receipt. We've got this demand and it's under review, or is there just nothing in the record? We don't know.
Candidly, Judge, I don't know the answer to that. I know that as far as I can tell, what's in the record is that the letter was sent, and then I think the next response, at least as far as the record is concerned, was from Mr. Williams on behalf of Mr. McCue, saying that they were going to extend the policy limits. And as I was saying, the letter was sent on June 30th, but it was sent by a regular mail It was not sent by email, and it wasn't received by Mr. Bruce's counsel's office until July 9 or July 10. Again, it didn't say what his injuries were. The demand was not time limited. After that, as I said, Mr. Bruce's insurer and his attorneys would have undertaken a review of his medical records to determine, whether they were serious enough to warrant acceptance of the policy limits demand. On September 29, 2020, Mr. Bruce's counsel wrote back saying that he was extending the policy limits. Eventually, Mr. McCue's counsel responded stating his position that the offer had lapsed and there was nothing for Mr. McCue to accept. We filed a motion to enforce the settlement agreement with the District Court of Johnson County. After some briefing and oral arguments by the parties, the court granted the motion and found that the amount of time that had elapsed between the demand and the acceptance was reasonable under the circumstances. As far as argument, I don't have much to add to what's contained in our briefing. The first point I do want to kind of clarify has to do with timing. I think Mr. McCue has repeatedly said that the amount of time that elapsed in this case was over 90 days. And I think Mr. Bruce has repeatedly replied that the demand letter, which again was sent by a regular mail, wasn't received until July 9 or July 10. And if we're trying to decide what constitutes a reasonable amount of time for a defendant to consider a demand and decide whether to accept or reject it, I think that the clock has to start running from when the demand was actually received by the defendant. The next point I want to make is that the arguments that have been made by Mr. McCue to the court below and in this appeal are at odds with an important public policy of the state, which is that the court system encourages the early resolution of cases and out-of-court settlements. Turning to the actual substance of the appeal, both parties acknowledge that the demand was not time limited in any way. It was not withdrawn before it was accepted. And I think both parties acknowledge that when a demand isn't time limited under Kansas law, it remains open for a reasonable amount of time. So I think the issue before the court is a pretty simple and straightforward one, and that is, what is reasonable? And unfortunately, the case law.
It may be a simple question, but is it a simple answer? What case law is out there on whether 90 days or 60 days or 120 days?
Your Honor, I've looked, I tried to research this issue both in and outside Kansas. I really haven't found much authority on, trying to shed light on a specific amount of time that would be reasonable. But what I have found is that reasonableness, it kind of depends on the totality of the circumstances, I think. So it's always going to be a fact-laden inquiry. And I think Your Honor alluded to this example already. In the context, if this were a pre-suit demand and the statute of limitations was approaching, then I think that would weigh in favor of considering a shorter amount of time to be reasonable. Likewise, if the lawsuit had already been filed and we were approaching trial, if trial was a few weeks away, I think that would also weigh in favor of a shorter amount of time, even if no time limit was specified in the demand. Neither of those circumstances is present here. The lawsuit had already been filed. The case was in its infancy. As far as I know, there were no discovery deadlines. There were no real deadlines of any kind. Turning to some other factors that I think weigh in favor of considering the amount of time that elapsed in this case to be reasonable, I think the court needs to consider the fact that, again, this was the first time the defendant or his insurers and attorneys had received any medical records from Mr. McCue. This was the first demand they received. They were pretty much in the dark on what the nature and extent of his injuries were. So they had to start their evaluation of the case from scratch when they received the demand sometime in July 2020. I think the other thing the court needs to consider is that just the sheer volume of the records that were provided in this case. I mean, we're approaching 9,000 pages of records. I don't know how many people State Farm employs to do these medical records reviews, but regardless, that is a lot of records that you have to get through, and it takes time. And the other thing I would say, and again, Your Honor alluded to this previously, if there was some pressing need for a response to the demand within a specific period of time, it is easy enough to include that sort of time limitation in the demand itself. Obviously, in the world of personal injury claims, time limited demands are extremely common. There wasn't one here. There wasn't a withdrawal of the demand. Your Honor referred to the Kansas Tort Claims Act, which I'm going to take. I candidly not familiar with it, but I'm going to take your word that it allows 90 days.
And I could be wrong. So whatever the statute says, it says. But that's my recollection as an old man.
Yeah. I would also point the court to a Missouri statute, section 537.058, which imposes a number of requirements for if a plaintiff wants to expose an insurer to the possibility of some extra contractual penalties, then the plaintiff needs to fulfill a number of requirements. And one of the things is if he submits a pre-suit demand and he wants to put a time limitation on it, the time limitation can't be for less than 90 days. So again, it's a Missouri statute. This wasn't a pre-suit demand, but I think if the court is looking for, a yardstick to determine what's reasonable, I think there is statutory authority that says that 90 days to evaluate a demand in a personal injury case is reasonable, particularly under the facts of this case, where the records are, so voluminous. The insurer and the defendant's attorneys are essentially having to start their evaluation from scratch. And I would also point out that the demand in this case was submitted was mailed in June 2020. The world was in the midst of a global pandemic at the time. We still are, but at that time, in or around June or July, it was still relatively new. It was still getting worse, not better, and everything was sort of slowing down. So to sort of sum up, Mr. McCue submitted a demand in this case that was not time limited. It was not withdrawn before it was accepted. He did not provide any treatment records or demands before this demand that was mailed at the end of June 2020. Again, he didn't withdraw it before it was accepted. The records he did provide were extremely voluminous, and it takes a considerable amount of time to review those records and review the claim in light of the injuries that are being claimed here, and to decide whether the demand is going to be accepted. The demand was accepted in this case. Mr. McCue submitted a demand for the policy limit. It was accepted around 81 or 82 days later. And I would ask the court to affirm the district court's.
Well, I've got some questions for you. First of all, the old man was wrong. KSA 12-105B gives 120 days for a municipality to respond. The 90 days is 90 days after that is done to file a lawsuit. So had that been on the bar exam and I just took it, I would have gotten close, but they would have docked me for some points. But more importantly, my question is, and it seems to be Ms. Gurney's best argument, not that she hasn't made a lot of good ones, but her best argument is that which you've I can't blame you, tactfully have avoided thus far. So I'm going to ask you about it. What significance is there in when the response had at the end of it? If it would have just ended with, I'm extending the $250,000 policy limits period and ended there, that's one thing. But then there's a next sentence, which I guess is third sentence. Quote, please let me know if this is accepted, period, close quote. What significance does that have? And why, if you're accepting an offer, would you ask, let me know if my acceptance is accepted?
Sure, Your Honor. I didn't send that email. I mean, the one thing
I know you didn't, but you were in the, just as Ms. Gurney did not send neither one of you are responsible. You have plausible deniability, but from a legal perspective, what's your best argument on how we should interpret that?
Yeah, I'm only saying that I don't know what Mr. Williams' intention was with that email. The only thing I can say is that a demand for the policy limits was submitted to Mr. McCue's attorney, and that demand was met. Mr. McCue's insurer decided to tender the policy limit, so we have an offer and a mirror image acceptance. And I'm not sure, I don't really think that sentence at the end matters at all. I think the contract had already been formed when Mr. Bruce's attorney indicated that the policy limits demand was going to be met.
Thank you.
And Mr. Wasserman, your time has expired. So Ms. Gurney, you have 5 minutes of rebuttal remaining.
Yes, Judge. Mr. Wasserman didn't address this in argument, but it was in their brief, so I'm just going to address it quickly. Plaintiff does acknowledge that we did request the transcripts late. However, plaintiff did file a notice of appeal timely. So I just want to note that I believe this is not a substantial failure to comply with Supreme Court rules such that a dismissal of the case is warranted here. And I would just ask the court, as we're doing today, to consider the case on the merits as opposed to a procedural defect with our brief. Regarding defendant's arguments here, 91 days, even if there's 8 days for mail, it's still unreasonable. I mean, the demand was sent and plaintiff didn't hear anything. No confirmation of receiving the demand, nothing. And Mr. Wasserman's correct, the reasonableness depends on the circumstances, but I don't believe it matters what stage the underlying case is in. We've provided everything. Here is 8,700 pages of documents to evaluate, all of the medical records, all of the billing records, everything. This isn't, here's 10 pages you can review in 20 minutes, but we're hiding the ball as far as giving you the complete picture of what's going on here.
Doesn't the stage of the case is in, though, go to whether there's prejudice? I mean, for example, if I'm defense counsel and you send me a demand and I know and you tell me your statute of limitations runs next week, and I've got 10 other demands laying on my desk in which they've already filed a lawsuit, it seems like reasonableness might mean that I would respond to the one where we're up against a statute of limitations before I would respond to the ones that aren't up against a statute of limitations.
Well,
would you agree, disagree? Or?
I disagree. I think the insurance company is obligated to respond to each claim promptly. And here, waiting 3 months, that wasn't prompt. I mean, Mr. McCue sitting here thinking, I need to get more lawyers involved. I need to emotionally get ready to prepare to move forward with this case. This is causing me a lot of stress. I haven't heard anything, so I need to be prepared to move forward. I'll say the insurance company, yeah, they have to look at 8,700 pages of records because we provided the whole complete picture, but they've got thousands of adjusters working for them to do that. I mean, the insurance company expects everybody to move fast. Everybody knows they cut their own counsel's billing because they always think they're taking too long to work on stuff. Well, why can't they get the records, get them reviewed by their in-house experts and people within 30 days and get a response back to plaintiff? I mean, I think that's reasonable in this case, whether there's a time limit demand included in that demand letter or not. I don't think, not including information in the demand letter about Mr. McCue's injuries is necessary when we're saying, look, here's the CD that contains the police report showing clear liability and all of his medical records documenting treatment, including multiple surgeries in a short amount of time right after this wreck for an acute injury to his ankle. I mean, it is very, very clear.
We would agree, would we not, that whether it's required or not, that best practice would be to put some type of deadline for an offer
I don't
in
disagree.
any contract, and in particular when you're dealing with a case like this.
I don't disagree with that, Judge. I think that's correct. I think you would want to, if best practices dictate, you put in a time limit in terms of when that offer is going to expire. However, you're not required to. There's no obligation that you do that. Our position is that offer lapses such that it's off the table after a reasonable amount of time. And defense counsel knew that when he wrote back and said, hey, I'm offering the policy limits. Are you going to accept that? Real briefly, defendant's counsel made mention of public policy favoring out-of-court settlements. But I would say here, there's no settlement at all. I mean, defense counsel wrote back and said, hey, 3 months has gone by. I mean, he didn't say that, but everybody knew that. I'm extending these policy limits. That's an offer. That's a counter offer. He's saying, are you accepting this? And we said, no, it's off the table at that point. A reasonable amount of time has passed such that our offer to settle has lapsed. And so just in conclusion, I would again ask the court to reverse the district court's judgment and order granting defendant's motion to enforce settlement entered February 24th of 2021 and remand the case for further proceedings. Thank you.
Thank you. Thank you both for your arguments. We will take the matter under advisement and get an opinion out to you as soon as we can.